Good evening, and thank you for joining us for this webinar on California's COVID-19 rent relief program and expanded tenant eviction protections. My name is Richard Bloom, and I represent the 50th Assembly District in the California State Assembly. It has been a long 17 months for all of us, filled with a great deal of loss, from the loss of loved ones to the loss of meaningful work and other opportunities. The pandemic has exposed cracks in the social safety net, and none could be more obvious as an example as the Employment Development Department and the challenges unemployed Californians are continuing to face in accessing their benefits. My colleagues and I have already begun working on legislation and additional funding to address some of the issues with EDD, and will continue in the years to come. My commitment now, however, is ensuring that you get paid the benefits that you are owed. If you need assistance in contacting EDD, please visit my EDD assistance page for helpful information and to request our assistance. We have a backlog of requests, but as soon as they can, one of my staff will contact you to help connect you with EDD and hopefully resolve your issue. We know that many Californians have been unable to pay their rent during the pandemic, and I'm proud to have been a co-author of AB 832, which extended the eviction for non-payment of rent to the eviction moratorium for non-payment of rent to September 30th, and increased the funding for California's COVID-19 rent and utility relief program. This will now cover 100% of unpaid and future rent and utilities. California's COVID-19 rent relief program will allow income-eligible tenants and landlords to apply for 100% of outstanding rent debt and up to 3 months of future rent to help recoup landlord losses and, of course, to keep tenants housed. Last week, we received great news. The City of Los Angeles and the State of California announced that the City of LA will be handing over administration of their rent relief program to the state to administer. So beginning at 7 a.m. this Wednesday, September 1st, tenants and landlords in the City of Los Angeles will be able to apply online for the state's COVID-19 rent relief program at housingiskey.com. Again, that's housingiskey.com. If you have already applied to the City of LA's rent relief program, you will receive instructions from the city, but you may be asked to reapply at housingiskey.com. Just follow the instructions that the city emails you. The presentations in this webinar were recorded on August 17th, a couple of weeks ago, prior to this recent announcement. So there is a portion of one of the presentations that explains why City of Los Angeles residents could not apply to this program. I want to emphasize that has now changed. Starting Wednesday, LA residents can apply at housingiskey.com. So go online and apply. Now let's get started. Here with us tonight are a host of experts who will help guide you, our tenants and landlords, through the Housing is Key process, followed by a question and answer session at the end. I want to thank our special guests, Amy Wilson and Veronica Harms with the California Business, Consumer Services and Housing Agency, and Javier Beltran of the Housing Rights Center, who will explain the application process and where you can get help for the program. We also have Hannah Comel with Betzetic Legal Services, who will walk you through the eviction process and explain how the protections from evictions actually can extend beyond the September 30th deadline if you qualify for this program. We are lucky to have such experts with us tonight, and I thank each of them for being here tonight to share this important information. So I'll now hand it over to Amy Wilson, Deputy Secretary for Legislation at the State Business, Consumer Services and Housing Agency. Hi, Amy. Welcome.
Yes, hello, and good afternoon, everyone. My name is Amy Wilson. I am the Legislative Deputy for the Business, Consumer Services and Housing Agency. And it is within our agency that the California COVID-19 rent relief program is being administered through our Department of Housing and Community Development. So I thank and appreciate the Assembly member for inviting us and his team for working with us to hold this event to inform you more about the program and to respond to any questions you have about it. Let's see. I think Veronica, my colleague, will be joining me for the second part of this presentation, and she'll be controlling this slide. So thank you. A lot of people have heard in the news about changes to the program that happened during the summer that allowed us to more swiftly deliver rent relief to landlords and tenants throughout the state. And at the same time that those statutory changes that the Assembly member mentioned that he is one of the authors of also extends the eviction protections. So go ahead and keep moving, Veronica. Our goals today really are just to briefly touch on the state eviction protections. And then of course, Hannah will delve into them much more in detail. And then for us, we'll really be doing this, this second section here, which is, telling you about the rent relief program, things it covers, eligibility, how you can get help locally if you need it from our network of community-based organizations, and then what to expect and how to do things like check on the status of your application. Let's keep going. So let's see. Sorry, I need to just quite slightly adjust my screen. Hold on just a minute. There we go. So just by means of kind of setting the stage here, it was federal rental assistance funding that makes this program possible. There were two bills that came from the federal government, one back in December called the Consolidated Appropriations Act, and then more recently under the Biden administration, the American Rescue Plan Act. You might have heard these names in the news. They had a lot of funding for all sorts of issues to help Americans respond and recover from the pandemic. Included among them is rental assistance. And so that first bill, which we call round one, the funding there, and then the round two funds together, will deliver approximately $5.2 billion in federal funds to California and to local governments. The way the funding was structured, the federal government directed some of the funds directly to large jurisdictions, and then it gave the balance of the funds to the state to administer for smaller jurisdictions. And so to administer these funds, there are a number of state laws that were enacted. They're listed there, AB 3088, SB 91, and AB 832. And they set the authority for delivering this money through a program structure. And what it essentially covers, the kind of the heart of those bills are setting the parameters and the kind of program structure for the financial assistance for landlords and tenants to pay their rent and utilities, eviction and other protections for non-payment of rent through September 30th. And then after September 30th, a modified court procedure related to evictions that runs between October 1 and through March 31 of next year. So go ahead, Veronica. The Assembly member already touched on it, but I'll just briefly explain that because of the way the federal government opted to give large jurisdictions direct allocation, and then the state an allocation for the balance of jurisdictions. There are a number of different ways that rent relief is being delivered to Californians. And so we've kind of lumped those into three categories that we call option A, option B, and option C. And I'm just going to briefly touch on those so that you understand where LA County fits into all of this. So for counties under 200,000 in population and all the cities within them, That would be like Mono County, Kings County, Napa, small counties, basically. All those funds are being administered through the state program, through our housingiskey.com website, and we call that option A. For the large counties and cities that have more than 200,000 in population, they received a direct allocation from the federal government. But then because we received a large amount of money, they also are eligible for a block grant from state government in California. It's federal money, but the money would flow through the state. So those large counties could decide how they wanted to manage things. They could join the state's program and do an option A. That's what LA County did. So their funds are being administered by our program. And everyone who lives in LA County is, they apply through our program and our portal. Another option is that these large counties could administer their funds locally according to the state program rules. And that's both their direct allocation and their block grant. That's what LA City is doing. And so people who live, residents of LA City, they cannot apply to the state program right now because all of the program resources are being administered locally through the City of LA's program. And there are many other places throughout the state that have also chosen that, and we call that option B. And then finally, option C are a few jurisdictions that decided that they did not want to follow the state program parameters, and in doing so, they would refuse the block grant from the state. And they're just doing their own thing. There are just a handful of those jurisdictions doing that in California, and that's called option C. We don't need to dwell on option C tonight, though. I think the most important takeaway for you is you're in option A, you're in the state program, and that if you have friends and neighbors, et cetera, who live in LA City, they're in option B, and they should apply through the City of LA's housing department for their rental assistance. Okay, let's keep going. Okay, so now diving in. So this is what we're talking about is the state program tonight. And so just a couple of things, a few things about the program we want to acquaint you with. First of all, the portal itself launched on March 15th, but the program was, just getting stood up at that time, and really has only in earnest been processing applications in the last few months. The program focus is informed by the federal laws about the use of these funds, and that's really to stabilize low-income households through the payment of rental arrears to landlords and tenants. And we also have a statewide network of what we call local partner network of organizations. These are our boots on the ground partners who assist people in their communities with to surmount language barriers. Maybe there's internet access, maybe just getting over the hump with applying. Maybe there's fear of interacting with a landlord. We have all sorts of, we have very capable organizations throughout the state who are there to help people. And just very quickly, as of this week, we have so far delivered $318 million in rental assistance and $1.7 million in utilities assistance to over 27,000 households. Again, that is just for all of the jurisdictions and that are participating in the state program. So as far as the program parameters, both landlord and tenant applicants, they may apply. Either one can apply or initiate an application. And they are compensated 100% for unpaid rent that's accrued on or after April 1st of last year. And then current and prospective rent is also offered to help people who are still transitioning, getting back on their feet. That's available in 3-month increments. And people, once they have an active application, they can kind of, not reapply. Their application is already, approved in the system, but they can kind of reactivate it in these 3-month increments as needed. And then we also cover past and prospective utilities. Although I would say that they are listed in that order because that's the prioritization. We always want to cover unpaid rent first and foremost, then, current and prospective, and then the utilities. The program also covers non-occupancy payments. We recognize that some people abandoned their leases. They went home, they went to live with friends, whatever they could do to try and make ends meet because they weren't able to pay their lease, but they may still owe on it. Or they, even if the landlord has kind of just forgiven the part where they left, they may still owe for a few months where they were living there and they haven't paid. Those situations are covered as well. So we encourage people to apply, even if they're no longer living in the, in the actual premises that they owe for. And then also the payment can go either to the landlord or the tenant. The best practices that come from the federal government, they really want us to try and deliver that money directly to the landlord. But we recognize that sometimes landlords are not willing to participate, or it's hard to reach them for whatever reason. And so we don't want to deny the opportunity to deliver those funds. And so we can, after following kind of a protocol related to that, we can direct the payment to the tenant, and they must remit it under state law within 15 days to the landlord. Okay, let's keep going. Eligibility. Who is eligible for this program? So this is all derived from the federal laws. So we don't have a lot of flexibility in some of the broadest, these broadest eligibility and eligible uses. And the first main one is that the eligibility rests on the household, the tenant household. And so they must be involved in this application process. And their income must be at or below 80% area median income. And the application process helps you determine your median income. If you're not sure where you fall, that we can help you with that, and so can our local partners. Another area of eligibility is if you're at risk of experiencing homelessness or you're experiencing housing instability, you've experienced financial hardships due either directly or indirectly to COVID-19. And then importantly, there's no proof of citizenship or immigration status necessary to be involved, to participate in this program. As I already mentioned, allowable uses are, the past rent due, prospective rent, utilities due, prospective utilities, and there is kind of a final category called housing related services, which is kind of the last use after families are stabilized, that has to do with some other services like relocation and things like that. The other important thing to know is that households can receive between 15 and 18 months of assistance depending on their circumstances, because we recognize that they might have 12 months of arrears that they owe either all or a portion of, and then there may be some need going forward. And so that's set by the federal parameters as well. Let's keep going. So how and where to apply? That's an important question. So we have our portal is located, and the portal is located at housingiskey.com. As you can see underneath the kind of banner there, you can see a number of languages represented. The website is available in 6 different languages. And then you can, so you can access a whole range of information there to better understand. And then you can enter the portal to start your application. Let's see. So a lot of people, of course, this is all on the website. So, you don't need to memorize it all right here, but just to be aware of the types of things that you will want to have handy when you start your process. Because you do need to have some kind of way to validate your eligibility on the renter side. And so we're trying to be as flexible as possible on how tenants and landlords can meet the requirements. And so these are examples of things that you might want to have handy to demonstrate eligibility. You don't have to have all of them. Notice it just says one of the following. Also, proxy eligibility is something that we try to do because we know that it's often easier for people if they already have received some kind of verification from the state or federal government around a program that they participate in, such as CalFresh, Medi-Cal eligibility, things like that. If you have your card or you have your certification letter, you can send a picture of that. You can, there are a range of ways to establish your income eligibility. And then similarly, people often have questions about a lease. Do I have to have my official lease? If you have it, that's great. If you don't, there are a number of ways to kind of demonstrate that you have been in a regular payment relationship with your landlord. There are a number of ways to validate that, and case managers from our program will work with you to help you, to land on the right one if you're not quite sure how to do that. Of course, the reason that we often why we also emphasize landlord participation is because they often have those types of documents. They have the paperwork, they're the paper trail that often tenants don't have. And so involving them in the process after a tenant has completed an application really does speed the approval by providing that verification. And then also it allows for swifter delivery because the money can then just be wired directly to the landlord and to eradicate that debt. The one thing I would say is, these are examples. This is not written in stone, but it gives you a good idea. And that when you go through we have other slides. In fact, let's move to the next slide. Let's see. Yes. So it's actually the next slide, but that's okay. We'll get there in a second. I'll pause. I'll go through this and then I'll return to what I was going to say in just a minute. So just a reminder of how the application, or not a little flow chart of how the application process works. So as you can see, starting on the left, either a landlord initiates an application or a tenant initiates the application. Our goal is to have both, as we said. That's our ideal situation. So if they are submitted by both, then they're matched in the system, and we kind of head up this top row up to the right. And we're able to match, and everything's completed, and the 100% payment is delivered to the landlord. If we head kind of more in the middle path, and we have a completed application from a tenant, for instance, we have to reach out to the landlord, and we have like a 5 to 7 day protocol for reaching out to the landlord a number of times, by a number of means, and to get them to apply. If they apply, then again, we're back on the top row and we're moving along and the money goes to the landlord. If they do not respond within that 5 to 7 day window, then the application is completed by the tenant, signed, and the payment is made to the tenant, which must be then remitted to the landlord. The unfortunate situation that we do not want to get in is that dark blue one on the bottom, which is the landlord applies, but the tenant does not. We absolutely need the tenant's eligibility to be able to process the application. That's through the federal parameters. That's not our rule. And so until we have a participating tenant, that application from the landlord is kind of just in a holding pattern. It doesn't get rejected. It just gets kind of it's kind of on hold, and then there are efforts made. We can help work with the landlord to try to outreach to the tenant, for instance, using our local partner. But until that point, it's an incomplete application. Okay, almost done here. The only other thing I really wanted to share is that we have a whole team of case managers I know people are concerned that they might not be eligible, or their situation is so unique that they're not sure if they should apply. And my main message to everyone is apply. If you have questions, you can get help through our call center. You can get help through our local partner network. You also, once you submit your application, it's assigned to a case manager. A case manager can outreach to you, and you can work to fine tune your situation based on, you know, your particular circumstances. Please don't hesitate. We are eager and willing. We have ample resources, and we want to deliver them. The last thing before I hand this over to Veronica is just that, you know, I told you those stats, you know, about 27,000 households already served, over $300 million delivered. We are processing between 4,000 and 5,000 applications a week. We are continuing to build up our capacity. We're trying to get to about 8,000 a week. And right now, we're not there yet, but we're almost there to do a 30-day turnaround from a completed application, then outreach to the landlord, finalizing all the payment details, and you know, processing the payment. So I think with that, I'm going to hand it over to my colleague, Veronica. Thank you. Veronica, you're on mute.
That's always a hazard with being on Zoom. So thanks everybody for joining us this evening, and thank you to the Assembly member for having us. I'm going to go a little quickly here. I know we have a lot more to get through tonight, but I wanted to let you guys know that recently, back in June, the program did simplify the application to apply for rent relief. We were hearing that it was taking upwards of 2 to 3 hours to apply, and we realized that that was not ideal. So we have reduced the time it takes to complete the application to about 30 minutes. And since then, we've obviously had a larger intake of applications. It's quicker for us to review, and people are applying and getting assistance quicker. We also heard from individuals that language was an issue, and so we professionally translated our website and materials into 6 different languages. And we also simplified our website so that it's easier to navigate and find the information that you need. So there are a variety of resources Amy was speaking about earlier in her presentation on how we are communicating the rent relief program to individuals. We have a lot of our materials online, and it's, again, available in multiple languages. We've also partnered with Urban Footprint to use data to help inform where we market the program, where we can reach those most at risk, and where we need to have our local partner network, boots on the ground, reaching those individuals. And so the other way we are communicating and getting resources out to the community is through our local partner network. You know, we have over 120 organizations that are available to help. I mean, we have one joining us here today, and I'll hand it over to him in just a little bit, but they really are there to be the boots on the ground and help people fill out the application, be a place to drop off documents, go to people's houses to pick up the application documents, and just be a resource for individuals who have questions about the program. And then there's also our statewide United Way 211 campaign that individuals can text rent and receive information and go through our eligibility quiz as well. So again, just briefly, we have over 120 partners statewide in our partner organization network. They serve 22 different languages in person and more by the phone. And they're available to be in person, by phone, or at your home. And they're available to help fill out an application or upload the required paperwork. We do have an appointment number. It's listed here. It's also on our website at housingiskey.com. And these are the list of organizations that service they're based in Los Angeles, but can service anywhere throughout the state of California. And these are also available on our website if you'd like to look. And don't forget to make an appointment if you need help at 833-687-0967. And just for those of you that are curious about the progress we're making in delivering rent relief to the state of California, we have recently published a public dashboard. It's available through our Housing is Key website. It only covers those programs that are participating in the state program, so the option A's that Amy mentioned earlier. And it provides the amount that we have paid out. And this is an old slide. We are now at over 320 million funds paid to over 27,000 individuals, households in California. You can also sort by the county and city of where you live to see how it's being administered in your area. And quick references that you can call and get information or visit any of these websites. So we have a call center that is available also to help individuals with the application process, 833-430-2122. And then you can go on our website and you can actually type in your address and figure out what program is available to you, whether it's a state program or a local program. So we're direct you what program to apply for. We designed the website and this lookup so that if you are in an area that is an option B or C, as Amy explained earlier today, you will be directed to the right application portal. And again, you can look at our stats and our dashboard, and then also to look up what partner organizations are in your area, or you can call the number as well. And I will hand it over now to Javier Beltran, who is one of our local partner organizations, to give you a background of their organization and how they work as a local partner network. Javier?
Thank you, Veronica, and good evening, everybody. So just to give you kind of an idea of what we do as a provider for under LISC and as a local partner network partner as well, just to kind of give you kind of the different tiers of services that are provided by each of the providers, and kind of knowing like exactly what the services provide. So under the first tier, they provide outreach and education. So we're involved in that as the Housing Rights Center. We provide education two ways. Since the pandemic has provided some difficulty providing in person, since there's a danger of contracting the virus. So we've provided either virtual, and also recently we provided in person. So boots on the ground. We provide flyers. We go to communal places. We even gone to laundromats and like just passed out flyers. And we focus throughout the county. So then you saw the list of providers there. And there's providers throughout the entire county that are doing this right now. We focus so far on various cities, but we focused on Santa Monica, North Hollywood, San Fernando, and then as well in Lancaster and Palmdale, which is also a big need up there as well. And then on the virtual side, we do provide city-specific virtual meetings for city residents, and in order to provide them information on clarifying the application process, the eligibility, what is covered and not covered, and in determining so if they're eligible for the program itself. So the second tier is more of technical assistance. So if somebody is having difficulty, providing documents once their application is submitted, then we're there to help them. And we literally actually go to people's homes in order to scan them and download those documents for them. And so especially, I know like in the West Side where we've helped out seniors there's a huge digital divide and are in need of that assistance. We've provided that as well for them. So then that way, that their application, that way it's thorough, it's completed, and then they could process the payment once all those documents are done, that are required, as mentioned in the previous slides, are submitted in. So we do provide that kind of assistance as well. And then we also provide information on the legal information that some folks may not know about AB 832 and the state laws, the local laws regarding tenant protections as well, because I mean, that is useful for folks who may not know that information as well. And then also just kind of information and guidance on where they can get these required documents, and provide that information and support for them to know, like, well, if you don't have this, then you can provide this document. And so that way it's a good way of providing that that little crutch that people may need if they're not understanding the application process. And then the last tier is organizations that actually do help people fill out applications. So this could be basically on the computer, helping them if there is truly a digital divide issue where the person who is trying to apply has not means for a computer or is unable to navigate that system. So they will be able to help those folks to do that. And so if folks need that kind of help, please try to apply for the Housing is Key through the Housing is Key website. And if not, try to call the number as well in order to try to set up an appointment, because they also can help through the phone as well. And we could provide assistance through the application process that way as well. So I think that is it on my part in regards to what we do. So Veronica, I'll kick it back to you.
Great, and actually we'll hand it over back to Assemblymember Bloom. Thank you.
Well, thank you, Javier, Veronica, and Amy for your very informative and concise description of a program that is fairly complex. We are going to have an opportunity to answer questions later on, but before we do that, we also have with us this evening Hannah Kummel, a staff attorney with Betzetic, who's going to provide information on the eviction protections that were extended under AB 832. Hannah?
Thank you so much, Assemblymember. It's great to be here, and I'm glad for the opportunity to be able to speak with tenants, because we know that these laws are very confusing, and we just want to take a minute to walk through them. Just wanted to confirm, is my mic working okay? Because I'm hearing a little bit of feedback. If perhaps the panelists could just let me know. There's
a little static, but we can definitely hear you.
Is this better? Is this okay?
It's fine. I think you're good.
Okay, thank you. Okay, so this is what we're going to go over today. First, we're just going to discuss the eviction process generally so that everyone's on the same page about how evictions work. And then we're going to go into various COVID-19 eviction protections, whether it's through the state, local law, and nationwide. And just a note about Betzetic Legal Services, we provide free legal services to low-income residents of LA County, and we do provide services regardless of immigration status. And we provide services in the city of LA, as well as other cities, including Beverly Hills, Culver City, and West Hollywood. So this chart I have in front of me is basically goes through all the different steps of the eviction process. And up at the top, you'll see the box that says notice. And so evictions start with some sort of eviction notice. And that could be, let's say, a notice to pay rent or quit, or a notice of breach of lease. It could also be for a reason that isn't really the tenant's fault, such as a notice that the landlord is moving in. There are certain specific requirements for how the notice must be given to the tenant. After the notice expires, and it could be a 3-day notice or a 15-day notice. All of the notices may have different time periods. But after the notice period expires, there is what's called the summons and complaint. So the summons is a document that the court issues. And the complaint is something that the landlord files with the court, saying that this notice has been served, and basically explaining the reason for the eviction. And so on the left and right of the summons and complaint are different ways that things can play out. So on your left, there is answer. Now, once the summons and complaint are served on the tenant, that generally means that it's given to the tenant personally handed to them. And so once the summons and complaint are served, the tenant has a very short timeline to respond. They have only 5 days. That doesn't include weekends or court holidays. to respond to the summons and complaint. And if they do respond, things can play out. Oh, I'm sorry. I see that there's no chart. Oh my gosh, I'm so sorry. Let me go ahead and share my screen. I thought that
that's all you need to do.
But here we go.
There you go.
Is everyone able to see it? Okay.
We can see it.
Okay, great. I'm so sorry about that. Okay, so you can see, you know, on the left is what happens when an answer is filed, and then on the right is when there's not an answer. So still going through the left column, it's possible that after the answer is filed, it's possible that the parties will settle. And that means they might reach an agreement that either the tenant is going to stay or they might move out. Alternatively, it's possible that the parties will not be able to figure out something that's mutually agreeable, and they will end up going to trial. Now, if the tenant wins at their trial, they are able to stay in their unit. But if the landlord wins, then what happens is basically the landlord gets a document from the court, which allows the sheriff to enforce the eviction. And then the sheriff posts a notice, a 5-day notice to vacate on the tenant's door. And after those 5 days are up, the sheriff can come and lock out the tenant. Now on the right of the summons and complaints, you'll see it says no answer. And so this is what happens if the tenant does not respond. Now, basically what happens is that the tenant will get what's called a default judgment against them, which means they automatically lose their case because they didn't respond in time. And that will lead to the same process where the sheriff posts a 5-day notice to vacate, and then the sheriff can come and lock out the tenant. And this is why we really stress that when you get a summons and complaint, you have only 5 days to respond, and you need to get legal advice immediately so that you don't miss your opportunity to fight for your housing in court. And then on this page, you'll see it says summons up at the top. Now, this is just an example of what a summons looks like. And again, tenants should just be aware of you know, the 5-day timeline. And if they get anything, any sort of court papers that look like this, they should go ahead and get legal advice immediately. So now we're going to transition to talking about the COVID-19 tenant protections. Now, first, on the left, you'll see state law. There is, the other panelists were alluding to the AB 832, the state law, does contain a lot of protections, both for non-payment evictions and also for other types of evictions. So we're going to go through those in depth. We're also going to just touch on the local laws, for instance, the laws that are in, you know, City of LA, Beverly Hills, County of LA. And then we're just going to explain a little bit about the CDC order, which is something that applies throughout the country. So first, we're just going to go through the state law. So if you can't pay due to COVID, it's possible you may have, you know, informally told your landlord through an email or a text or in person, and that's great. But under state law, there's actually a very specific procedure you need to follow to make sure that you won't be evicted. So under state law, there are 2 steps you'll need to take. First is that there is a state law COVID-19 financial distress declaration that you'll need to submit to your landlord. And you'll need to sign this under penalty of perjury, which means that it's, you know, it's under oath. You're saying that everything in there is true. It says send in the matter stated in notice. It depends whether if you're getting this declaration in response to an eviction notice, that may determine how you can return the declaration. And we'll talk about that in a minute. So that's the first step, is provide declarations to your landlord. The second step is that you'll need to pay 25% of the rents that came due for each month that you're using a declaration between September 2020 and September 2021. And this 25% payment can be when you submit the declaration, or it can be at the end of September 2021. So first, let's talk about the period from March 2020 to August 2020, because the state law actually splits up the months from March to August 2020, and then the later months, and it treats them differently. So if we're talking just about March 2020 to August 2020, there's only one step. That's you have to give a declaration of COVID-19 related financial distress to your landlord. And if you do that, that means your landlord can never evict you for not paying that rent. Now, it's important to note you'll still owe the rent, but it will be converted to consumer debt. And that means that your landlord can seek the debt in a civil or small claims action, but just not in an eviction case. And then here's this chart that just kind of explains what happens with if you get a 15-day notice for March 2020 to August 2020 rent. So as we discussed at the beginning, the eviction process starts with an eviction notice. So let's say a tenant gets an eviction notice saying, you need to pay your rent that came due between those months or leave. Here are the options. So first, at the top, the tenant could pay their rent. And if they do, they can stay. But we know that for a lot of tenants, that's not an option because they've been impacted by COVID and they might not be able to come up with the money. The second option is they could submit a declaration. And if they do that, then they can stay. The third option is, they could move out, but that might not be a good option because the tenant might not have anywhere to go. And at the bottom, if they do nothing, then they will likely end up in an eviction case in court. So this is why we really recommend that you submit the declaration. Now we're going to talk about the second period of time. So this is September 2020 through September 2021 rent. And that's kind of a weird time period. It's actually 13 months, it's more than a year. So for those months, beginning in September 2020, there are two steps you need to follow. First, you have to submit a declaration of COVID-19 related financial distress and we recommend that you do this for each of those months, just to be safe, for each of the months that you can't pay the full amount of rent. And you have to pay 25% of the rent for each of those months by the end of September 2021. And if you do those two things, then the remaining 75% of the rent, you cannot be evicted for not paying it. Again, you'll still owe it, but it becomes consumer debt. That means you can't be evicted, but you might end up in court about that rent. And so here's another chart. Again, at the top, if you get a 15-day notice for rent that came due between September 2020 and September 2021, you have a few options. The first is, of course, you could pay it, but you may not, it's possible you may not really be able to come up with the money in time. The second is you could submit a declaration and pay 25% of the rent for those months by the end of September 2021. And if you do those two things, you get to stay. Now, again, you also could move out, but that might not be a great option, or you could do nothing, but then you would end up in eviction court. Now, just want to be clear, as was discussed earlier in the presentation, this law was going to expire at the end of June, and then AB 832 extended the state law. And so many people may have heard about a deadline on June 30th, 2021, that you needed to pay 25% of your rent by that day. That is not true anymore. There's no deadline for June 30th. You don't have to worry that you missed the deadline. So again, now that deadline is September 30th, 2021. And then here is on this slide, you'll see on the left, this is an example of what a 15-day notice to pay or quit looks like. So you'll see it has some specific language from a notice from the state of California that there's a certain language that must be included in eviction notices for non-payment of rent. And it lists out which months of rent are owed and how much for each month. On the right, you'll see the declaration of COVID-19 related financial distress. And this is something that if a landlord is giving a tenant a notice to pay rent or quit for the relevant months, then they will have to also provide a blank declaration to give the tenant an opportunity to submit the declaration. Now, it's possible the landlord might not provide this declaration, and that's why it's so important that tenants get legal advice if they do get a 15-day notice, and just that tenants are aware of their rights and they know that they can submit a declaration of COVID-19 related financial distress, even if the landlord forgot to provide it. So a little bit more about this declaration. So again, you're stating under oath. That means that everything you say has to be true, because if it's not, you could face certain consequences. And so you're saying you can't pay rent for at least one reason due to COVID-19. And there are several different kinds of ways this could apply. One is that you had a loss of income. For instance, if you worked in a restaurant and you were laid off during COVID because of the pandemic, because the restaurant maybe had to close or couldn't do as much business because of the pandemic. The second is you could have had an increase in expenses because of the pandemic. Third is that maybe you had childcare or family responsibilities. Perhaps you had to either quit your job or reduce your hours because your kid's school was closed, and you needed to spend more time caring for them. Or perhaps you continued at your job, but then you had to pay someone to take care of your kids because the normal arrangements of school were not available. And then there's also this kind of catch-all category, other financial impact of COVID. So there are actually many ways that tenants can fit into the declaration, can qualify for the declaration. And you don't need to explain which reason applies to you. As long as one or more of them applies to you, you can sign it. And then finally, you also, this only applies, you can only submit a declaration if any government benefits don't make up for your loss of income or increase in expenses. So let's say your hours were cut or you lost your job, but then you're actually making more from unemployment. So you never really had a loss of income, then you wouldn't be able to submit a declaration. Okay, so this slide about no documentation required. This refers to some protections that existed before the state law. Some of them did require tenants to provide proof that they were financially impacted. Now, under the state law, you don't need to provide proof that you were financially impacted by COVID unless you qualify as a high income tenant. And that refers to, there's specific criteria for, tenants that, where landlords have pre-existing proof that they were making above a certain threshold. And so the landlord must have already had that proof. Unless they do, they can't ask you to demonstrate that you were impacted by COVID. So we talked a little bit about what happens when you get a notice. And it's important for tenants to be aware of these timelines. So if you do get a notice to pay rent or quit, you have to give the declaration back to your landlord within 15 days. the notice being served on you, that starts a timeline and you have to comply with that timeline. But it's important to know you can also give your landlord a declaration before you even get a notice to pay or quit. And it may be beneficial to tenants to do that, so it's kind of on their terms. They don't have to wait to hear from the landlord, and they know they're protecting themselves. And again, we believe that you should do this for every month that you're impacted and you can't pay the full amount of rent. And of course, you should keep a copy of the declaration and keep proof that you sent it to your landlord. So for instance, let's say you send it by mail, you can take a photo of the declaration before you put it in the mailbox. And then you can take a photo of the envelope that you used to send it to your landlord, just so that you can later show that you did send a declaration to your landlord. Now, I've been stressing this 15-day deadline. It's true that you should do everything possible to meet that deadline. However, it's possible maybe you won't meet that deadline. Maybe you were unaware of your rights. And so if you have a good reason for missing the deadline, the court could give you another chance, and there's actually a special procedure for that in the law. And we recommend that you seek legal assistance immediately to figure out your rights in this sort of situation. So what happens to the rent, all of that rent that, I said gets converted to consumer debt? So under state law, your landlord can sue you in small claims or civil court for that rent as early as November 1st, 2021. Now, it's possible that local law will give you more time, and that really depends on where you live and whether you qualify under those local protections. But the baseline is November 1st. That's the earliest it can happen. And if the landlord has already sued you, that case should be frozen until it can't move forward until November 2021. And if you do end up in court for this rent, you can raise defenses. Like you can say that, well, I don't actually owe all of this money because my landlord didn't make repairs. Or you can also countersue your landlord if there are any issues between you in this case. Also, a couple of other protections under AB 832. So tenants that submit declarations don't have to pay late fees. If a tenant has a security deposit, landlords can't just unilaterally take their security deposit and apply it to their unpaid rent from between March 2020 and September 21. The landlord has to get the tenant's permission to do that. And then if you owe rent from March 2020 to September 2021, and let's say you're applying to housing, the housing providers can't use this debt as a negative factor when they evaluate your application, or they can't use it as a reason to deny your application if you're otherwise qualified. So kind of linking this part of the presentation to what we discussed earlier with rental assistance, you might be wondering, so how does rental assistance fit into all of this? So there are actually many ways that rental assistance applications will prevent eviction. Now, obviously, if you are selected for rental assistance and the rental assistance gets paid out, well, there's not any basis to be evicted for not paying the rent, because even if, let's say, you owed $5,000, if the rental assistance program paid that $5,000, your landlord couldn't evict you for it. Now, and you'll kind of see that in the first bullet point. You'll remember that I mentioned you'll need to pay those 25% payments by September 30th, 2021. Now, if the rental assistance program pays that 100%, then, well, they're definitely meeting the 25%, and actually they're going higher than that. So you wouldn't need to, if the rental assistance program does pay an amount that's equal to 25% or more, then you're already protected from eviction. Moving on, if there are also a couple of other procedural protections that would apply. So for evictions that are based on non-payment of rent from March 2020 to March 2022, there's a process where, let's say a tenant is in court for this non-payment of rent eviction. The tenant can show the court proof that the rental assistance program already approved payments for the amount of rent that's being demanded in the case. And then what happens next is the court is going to set a hearing, and at that time they can either dismiss the case or they could set follow-up hearings if the payment hasn't actually been made yet. And they can prevent the lockout from going forward. And it's possible even if the tenant has already been locked out, the court could restore the tenant to possession of their unit. And just to note that this doesn't apply to tenancies that are new, as of October 1st, 2021. You have to already, your tenancy has to exist before October 1st, 2021. Now, another procedural part of the law is that I mentioned at the beginning that the landlord files a complaint with the court, and then the court issues a summons. And you'll remember that the summons is kind of what gets the whole process going. That's what triggers the 5-day deadline. That's what really gets the tenant involved in the lawsuit. So between October 1st, 2021 and March 31st, 2022, landlords actually have to follow a couple additional steps if they want the court to issue the summons. So they'll have to either show that, and this is specifically for evictions that relate to non-payment from March 2020 to March 2022. So for those evictions, landlords have to submit some statements under penalty of perjury that they applied for rental assistance and it was denied, along with the actual denial from the rental assistance program. Or they can show that, well, they applied, but either the rental assistance program or the tenants have not responded. So they're, they're stuck and they can't get rental assistance, and that's why they're bringing this eviction case. And so you'll see that it really, it doesn't make sense for a landlord to proceed with an eviction if the rental assistance application hasn't, at least been started. And this is just another reason that it really makes sense for tenants to go ahead and apply. Because if you apply, then at least maybe you'll have a protection if you end up in court. And if you get approved and your landlord's not moving forward with it, you can say, hey, look, I've been approved, and that can cause your eviction. And likewise, on this slide, you'll see that the landlord might not even be able to get the case moving forward unless they can submit some sort of statement about the application. And now we'll just speak briefly about other types of evictions. So until October 1st, 2021, the landlord can't get a judgment from the court for eviction unless there's a just cause for eviction. What I mean by just cause is there's certain specified reasons that are allowed for tenants to be evicted. And in normal times, this might only apply to certain areas, certain jurisdictions, certain types of housing, but right now it actually applies for all residential units. And so some of these reasons are based on the tenant's faults, like breach of lease or failure to pay their rent, nuisance. And some are what we call no fault just causes, because it might be that the owner needs to move into the property, or the owner is deciding they're taking the property off the rental market. And this applies unless the court finds that the tenant was guilty of unlawful detainer before March 1st, 2020. So basically, if the tenant would have lost their case before March 1st. So what this means is that right now, evictions for no reason are temporarily prohibited. Now I'll just touch briefly on local protections. So there are local protections, for example, in the city of LA, in Beverly Hills, in the county of LA, which actually applies not just to unincorporated, but to all of the cities in LA. And those local protections can also limit evictions. It's really a case-by-case thing, and we don't really have time to get into it in this presentation. But for instance, some of those protections prohibit evictions for unauthorized occupants or pets, or for no-fault evictions. So we definitely recommend that you seek legal advice, and you can also get some information from the city and county websites about these protections. And I'll just briefly mention there's this nationwide protection, the CDC order. We don't really need to get into it in depth because it's something that really just, we call it a last resort because all it does is it temporarily stops the lockouts through October 3rd, 2021. And we've described all of these other protections that will, that can, not just temporarily pause it, but can actually prevent the eviction from going forward. But if you are currently in an eviction case, especially if you have overstayed your the time that you're supposed to move out according to your settlement agreement, or if you've already have a judgment against you, this eviction order might be useful to you, and you should seek legal advice. So regarding lockouts, I'm talking about two different kinds of lockouts right now. So the first is a legal lockout that we discussed that can only happen through the sheriff's department. And this sort of legal lockout happens at the end of an eviction case when the tenant has lost, or perhaps if they signed a settlement agreement and then they didn't move out when they were supposed to. The sheriff's department is moving forward with lockouts, and you should seek legal help if you get a notice to vacate. Now, what's not legal is for tenants to for landlords to take it upon themselves to lock out tenants. So landlords are not allowed to change the locks. Landlords can't shut off utilities or remove doors or windows or remove the tenant's personal property to try to force a tenant out. They have to go through the court process. If your landlord is threatening to lock you out, you should seek legal help immediately. And then finally, here's how you can get legal help. So if you have received an eviction notice or a summons and complaint or even a notice to vacate, the main way that you can get legal help is go to stayhousela.org. And that's where you'll answer a few short questions and you'll be connected with a legal services provider in your area. And so Betsetic is one of those. And there are several other organizations throughout the county that all work together. And throughout, through Stay House, you'll be placed with one of those organizations. Now, if you live in the city of Beverly Hills, there's a special number you can contact Betsetic at, and you can be connected with an attorney at Betsetic. And likewise, if you live in West Hollywood, there's a phone number and an email address where you can get legal help. And then finally, if you're having issues with habitability or other sorts of harassment violations of your tenant protections, I just put the County of LA Public Health Department phone number here. That's one place to start, depending on what city you live in. There may be other resources, and so I would check in with the city renters resources, or if you're in the unincorporated county, with the county DCBA. And that's it from me.
Well, thank you. That was chock full of information, Hannah. We really appreciate it. It's extremely helpful to understand the basic way in which the eviction process works and the differences in the process that we have now. But I think the most important piece of advice you gave was seek legal assistance if you're at all concerned, if you receive a notice, if you're worried about what might happen, if you're not sure, it doesn't matter. Seek out legal assistance because this is a complicated area. You've received the outline today. You can begin to understand its complexity, but we want to make sure that you have the maximum amount of protection, and that's going to be with legal advice. So we have a little bit of time for questions. I'm going to begin with you all can turn your panelists, please turn your mics on and your cameras. And the first clarifying question is for Hannah. Please repeat the timing, the number of days according to whichever action or non-action. This is in reference to the very beginning of your presentation when the landlord sends a tenant a notice to quit. What's that important timeline that people need to keep in mind?
So it's going to depend on the type of notice to quit. If it's a notice to pay rent or quit, and if it seeks rent that came due between March 2020 and September 2021, that's going to be a 15-day notice. But different notices can have different time periods.
Thank you. Amy, can you please review the landlord requirements again?
Sure. So there's not just one way, but some of the examples of things that the landlord could provide are things that document or verify the tenant's assertions around the amounts that are owed. So a ledger or some kind of way to document what the balance of unpaid rent is. It doesn't have to be a super fancy kind of printout documentation. I mean, we are very flexible in all of that. Also, the rental agreement or the lease or some method of verifying that this person actually does live in the property that you are renting out. A W-9 is another example of a type of document that could be used because of all the tax verification that it confirms a number of items, and then also for tax purposes, it's useful as well. Those are examples.
Would a 1099 qualify?
So a 1099 would be on the tenant side. That would be like income received by the tenant. Right. Yes, and that would be fine. Another one I didn't mention, but another example of like a proxy eligibility is if you've received unemployment and you have that verification letter, that would demonstrate your eligibility as well. So there's lots of different ways to either document your income or your other aspects of eligibility.
And the same tenant asks about if you don't provide a 2020 tax refund statement, this person has not yet filed a 2020 income tax refund. Is expecting a refund, but the return has not yet been filed. It's on an extension until October of 2021. Is that something you can help sort out?
I think that with a case manager, there are other things. You don't necessarily need to submit a tax return or tax documentation. There are other ways, other things they can submit. So if that's still in process, then I wouldn't let that discourage you from applying. You should continue to apply. There are lots of examples in the portal of things you can use to demonstrate, and also the local partners can help you sort through that as well. If you call and talk with them, they can help you look at what would be the best thing.
All right. The next question is eligibility for the rent relief program dependent on hardships due to COVID-19?
Okay, so that one it's a little bit tricky because people want to think that there's like an exact nexus. And the thing is, it's very broadly defined. So we say kind of direct and indirect. We know that people have experienced all sorts of impacts And they're not always like a direct thing. Like, for instance, I worked in a bar and the bar closed, and so I didn't have a job. Like, that's a very clear connection, you know, you're unemployed from that. But there are all sorts of other ways that, you know, people have been impacted. And if they are income eligible, they should apply. The first round of funding, federal funding, was more explicit around, you know, documenting a COVID hardship. I mean, not that we had to cite it, but just emphasizing that that was part of the program focus. The ARPA funds are much more permissive around that, recognizing that part of the economic recovery and stimulus for our nation is to help people, you know, pay their debts and not be burdened by, you know, things owing rent, and also helping landlords, you know, meet their bills and pay, you know, get the money they're owed. And so it's not explicit in the ARPA funds. So do not let that hold you back, please. I mean, that's my constant mantra. Try to apply. You should apply to the program.
The next question is an interesting one. This individual is a senior that had a co-renter move out. And the person says, I can't afford to move somewhere else, but I also can't afford to pay the entire rent now. Can I apply for rent relief to help cover my entire rent after having a roommate move out?
Yes, yes. I don't see that as being a problem if they have, they're accruing arrears, and they can document that this is what they're supposed to be paying, and this is what their, you know, their limitation is, then that should not be an issue.
Next, we've received many questions about the length of time to apply and receive the funds. And I know you covered this in the presentations regarding the length of time, and also discussed during Hannah's presentation about evictions. But can we go over the timeline again? In cases where if someone has already applied for rent or utility relief, when will they know if they are awarded the money?
Sure.
And then when will they receive the money?
Mhm.
What if they do not receive the money, settle the rent before September 30th,
Mhm.
when the eviction moratorium ends?
Sure.
Is there a consequence?
Sure. And, you know, I want to emphasize that, you know, we understand that people are under a lot of stress and worry right now. I mean, it's, we are doing our best and trying to deliver this assistance, and to stand up this program and do it in a way that, you know, meets all the federal rules, but also is not too burdensome and onerous for people to navigate through. But California is so huge, and everyone has a unique situation. So trying to find that middle level, it's taking time, and we're learning as we go. And so we are constantly trying to improve our processes, and these types of conversations are really helpful. I'm reading all the chat and all the information so I can take that back to our program. And so that being said, you know, our goal, as I mentioned, you know, we are trying to, right now we're processing about 4,500 applications a week. Our goal is we're staffing up, ramping up our case management staff, and our quality assurance staff. And our goal is to do 8,000, at least 8,000 a week. We believe that will get us through our, looking at the backlog that we have right now. We're working on June applications right now to give you a sense. So if you've applied since then, like just to give you a sense of where we're at, everything's been assigned to a case manager. Everything from June has been assigned to a case manager, but we haven't paid out all of June yet. And so if at the point that an application is complete, so it has all of its pieces of documentation in it, everything is just buttoned up perfectly with no questions from the case manager's perspective. At that point, it should be no more than 30 days is our goal. But sometimes it can take some time to get to that completed application point based on, you know, the need to fine tune documentation, or someone mistakenly uploads their 2018 tax return and it looks like it's complete, but actually it's not because they needed to do the next year, you know, that kind of thing. And so So, all of these situations, just take a little bit of time and adds, it adds time. And so we understand, and we're doing our best and being as diligent as we can to keep moving through these applications. So I would say, though, about the September 30th, continuing on in the question, is that the way that the AB 832, this new law, is constructed, is that the new process that kicks in starting October 1, related to evictions, is such that the unlawful detainer action, although it can be initiated, it requires that both the landlord apply for rental assistance. They have to demonstrate that they have made an effort to apply for the rental assistance and secure rental assistance through the program before they can move forward in the unlawful detainer action. Meanwhile, when they give that notice to the tenant to say, you haven't paid, I'm going to try and evict you, that notice, that pay or quit notice, also reminds the tenant they have 15 days to apply for rental assistance. That effectively pauses the entire process. And so that's why I also keep emphasizing to everybody, apply, apply, apply. Because if you have a pending, basically kind of with some details, and I'm not an attorney and Hannah is, but with some, some slight, detail or variation, the upshot of that situation is if you have a pending application for rental assistance, that is going to put a pause on that entire unlawful detainer action. The landlord may try to initiate, but it cannot move forward until there is a final decision from the rental assistance program. And so, although we're trying to get the money out the door to you as soon as possible, one of your best bets is to have a pending application in, and that's going to give you that that kind of that safety assurance that they cannot move, the court cannot process that action. And I think I forgot one other element of the question. I'm trying to remember what it was, but that's okay. We can come back to it. If
So we have an individual who is living in a motel and finding it hard to pay every day. That individual should get an application on file. Is that right?
I think they should, because that would be, they'd be at risk of homelessness. And so that is one of the qualifying triggers. So I think that although, it again, yeah, it doesn't exactly like COVID-19, et cetera, hardship, just I think the imminent risk of homelessness is qualifying.
And we really only have time for one more question, unfortunately, but we will try to get answers to folks who have provided us with questions over the next few days.
Sure.
We won't leave you hanging. We will try to reach out to every one of you. And the last question really seeks reassurance, which I think is what this program is all about. It's reassuring people that they won't end up homeless, that their rent will be taken care of, and for landlords that they will receive as much rent as possible from tenants who are having difficulty paying. So this individual says, it seems to me like the rules keep changing, 25%, 80%, 100%, June 30th, now September 30th. I'm worried that the rules will change again. What if the rules change or a court ruling allows landlords to recoup unpaid rent? Will I have to pay or still owe more money to my landlord?
Well, yes, I think you're right, Assembly Member, that it definitely reveals kind of the level of uncertainty that people are feeling. And, certainly I don't have a crystal ball, and certainly I don't have, I'm not, I'm not sure how, the courts, what happened at the Supreme Court or other things, but I believe in the legislature's intent to transition with the economy into this modified process, which emphasizes protecting people who are eligible by putting a pause on all eviction actions through until they're able to secure their rent relief, and then so that's one piece of it. And then, as far as the changing numbers, we recognize that has created some confusion, but this most recent change was AB 832 was intended, in fact, to address that confusion and to just make it as simple as possible, which is that everyone gets 100%. There's no 25%, there's no 80%. And everyone is at 100% moving forward, whether it's, what you owe in the past, it's prospective, whether it's utilities. And so adding that kind of just, kind of uniformity has, it's really upped our application participation, and it's also streamlined our ability to get the money to people. If you'll indulge me, I did remember one other thing I didn't mention that I wanted to, which was that there is sometimes people are rejected from the program, and it's very low. It's less than 1% of applications, and it's often because of some kind of misunderstanding around the income eligibility rules. We found there's an appeals process, and we found that the vast majority of cases, when they come back and they clarify the information, they are accepted into the program. So again, sometimes, we're doing the best we can, but it is a portal on a computer, and sometimes, you put in the information and it, things happen. So please, follow up with a local partner, or call the call center, or reach out to the Assembly member's office, who can help us look into some of these situations to try to get to the bottom of them.
And Assembly Member Bloom, just to add just a quick piece
Please.
regarding people's uninsurance, like their inability to get legal assistance is key in these situations in order to ease the tension and the stress. And I do recommend stayhousedla.org as a place to go. They have clinics, they have workshops on these particular issues, and right now they've starting with AB 832, they'll have an explanation, they'll have one-on-ones with folks as well. And then if they need actual legal assistance, legal counseling, they can get connected to one of 10 legal service providers in LA County as well. And if it escalates to a situation where they need representation, then that is available as well if it happens to go in court. So, I mean, that is a good way for folks to at least get some of their questions answered regarding on the legal side. And I know there's a lot of changes, and folks are confused. I mean, we're confused once it comes out, but we figure it out, we interpret it, and then we can provide answers to the folks who need it, and provide some guidance in regards to how to approach those situations. Stayhousedla.org.
All right, folks, that brings us to the conclusion of our program. I want to thank everyone for participating, and I really want to thank all of you who have been watching and taking down notes. The most important message you can receive from everyone here who is telling you how this program works is you don't have to go this alone. All of the folks here who are participating tonight are available to you. The organizations that you've heard about are available to you, and you should not hesitate to call, to email, to text, to log on, and get the help that you deserve and that you need. So thank you all. Good night to each and every one of you, and we'll try to do this again very soon. Thank you.